case, and thank the lawyers for participating in this oral argument by Zoom. I've said this a lot of times, but I'll keep saying it because we do appreciate the lawyers doing it, and it enables the court to keep doing the work of people in the state of Tennessee. We have any technical problems, we'll just take a pause, and Mr. Hibner and the AOC IT people will resolve it quickly. I'm sure things are going very well, but so we don't anticipate any. Call the case, please, Mr. Hibner.
Brittany Borngne, ex-rel, Miyona Hyter versus Chattanooga-Hamilton County Hospital Authority et al.
We'll hear from the appellant.
Good afternoon, and I want to thank you all for doing this by Zoom. I didn't particularly want to travel across the state, and I know no one else did, so a lot more convenient. As your honors probably know, this is a case where I represent a child in a birth injury matter that was tried to a jury, and there was a defense verdict. The 4 issues before the court today all involve pretrial matters. None of the trial issues were raised on appeal because I don't think they are where the problem lies. The 3 main issues that we have brought up is the court's interpretation of the case of Lewis versus Brooks. The second matter is the propriety of the errata sheet, which was filed in the case. And the third involves the requirements put on a physician fact witness who resides in Texas. With a little bit of background, Lewis versus Brooks, I happen to know something about because I was actually on that appeal. That was my case where this case emanated from. And Lewis versus Brooks, by way of background, involved a physician who was covering over the weekend for 2 other physicians. They were not in practice together. They didn't have anything to do with each other. My client, Lonnie Lewis, goes to the hospital because her water breaks on Saturday morning, and they call Todd Brooks, who is the on-call physician. Her 2 treating physicians, Doctors Moore and Lawrence, didn't even know she was in the hospital. Malpractice occurred over the weekend. The baby was born brain damage, and we filed suit. The issue arose when we were deposing Doctors Moore and Lawrence about the care provided by Dr. Brooks on that Saturday morning. And Judge Childers ruled that we could not ask these 2 physicians who were not involved at all about the care rendered by Dr. Brooks. And thus was the Lewis versus Brooks case. It went up on appeal, and the Western Section affirmed Judge Childers in that ruling.
Mr. Holton, I'm sorry to interrupt you, but in that particular case, while the facts are true that it's not the same relationship between the 2 physicians and the relationship that we have here between the physician and the nurse practitioner, it looks to me like the appellate court in Lewis v. Brooks was not as concerned with the nature of the relationship than it was concerned with the fact that you were asking a fact witness to give expert testimony. And that seems to me to be what the Court of Appeals focused in on as to why that was improper.
Well, I think the Lewis versus Brooks holding is limited to those facts. And it says in the opinion, under the facts of this case, there was no relationship whatsoever involving Brooks and Moore and Lawrence. Now, the Church versus Perales and Waterman versus Damp cases address the fact that a treating physician is by nature an expert. They always are. They're an expert in their own treatment. So they're not the paid expert that people are used to. And that's the difference. In this particular case, though, it is way different. And I think one quote from Dr. Sieber's deposition probably says it all. I asked him, what does it mean? And by way of background, all patients, including my client in this case, are admitted under Dr. Sieber's name. The midwife cannot admit anybody. He must do it. And I said, what does it mean when somebody admits a patient? What responsibilities do you have? And his answer to me was, it means that ultimately I am responsible for the care of that patient. Clearly, that is different than a scenario where a doctor doesn't even know the person is in the hospital. The midwife in this case was his employee. He was her supervisor. He had to countersign every order she wrote. He was responsible, as he said in his own words, I am responsible for her care. That is the difference. And when I asked Dr. Sieber, there were two questions that prompted the adjournment. The first one, I asked, what would your expectation be of your employee, the one you are supervising? And at that point, counsel for Dr. Sieber instructed him not to answer. Now, this is an employee. This is not two doctors treating these are two doctors, or one doctor and his employee, nurse midwife, who are collaboratively taking care of this lady. It is a collaborative effort. That is the difference between this and Lewis versus Brooks. At that point, I asked one other question about, would you expect someone to call you? And the deposition was adjourned. The issue that's involved here is the relationship that we have. This is an employer-employee. If you take Lewis versus Brooks and you interpret it that no one ever has to give an opinion if they're not involved in something, then by way of example, if I'm a trucking company owner and my employee is out there driving on drugs, has an accident, I'm deposed. Well, Mr. Holton, should your employee have been driving on drugs? That's an opinion I'm going to give, but I'm giving it as his supervisor. And I would say, no, he is not allowed to. If you take Lewis versus Brooks to its logical end, it would involve any time someone is asked an opinion. And that's what happened here. This is not a arm's length relationship. Dr. Sieber knew the patient was in. It was his patient. He was responsible for all the care that was provided. And because of that responsibility and the fact that he was this woman's employer, we should have been allowed to ask about the conduct of his employee who he was supervising in this particular case. So that there's a vast difference, I would say, between this case and Lewis versus Brooks. And I think most important is the Supreme Court holding in Lee Medical versus Beecher, where the Supreme Court talked about privileges and talked about how the fact that privileges fly in the face of the purpose of trials, which is to seek the truth so that disputes are not decided by legal maneuvering, rather they're decided by the facts. And if we allow people to not answer questions in this fashion, particularly when it's their employee, they're responsible for that person. That is the difference here. Now, the court sanctioned me for asking those questions. I was told that if we resumed the deposition, I would have to pay for the doctor's return, et cetera, counsel fee. And I would submit that clearly the question of what was your expectation of the employee you were supervising, that does not cross the line on Lewis versus Brooks in this circumstance, with all due respect. And I would submit again that if we allow this to be the rule, it's Lewis versus Brooks is not limited to a medical malpractice case. If you take that approach, anyone who's asked to give an opinion can say, excuse me, I wasn't there. The difference here is this was a collaborative effort to treat my client. If I might, moving on to the other two issues that I see my time's waning down. The issue of the errata sheet, which was involved by the nurse midwife. She was deposed in the case. Her deposition was typed up. One of the things they reviewed in the deposition was the fetal monitor strip, which I don't know if you're familiar with it, but it's a device that measures the baby's heart rate and the mom's contractions. And she went through the strip and marked certain portions of the strip as indiscernible. And when she testified, she said if it's indiscernible or indeterminate, that is worrisome because it could be a problem with the baby. After the deposition was typed up, it was submitted to her for her errata sheet. And she submitted an errata sheet on April 16th, 4 days late. And we told counsel it was fine. There was some issue with mailing it to her. But the errata sheet she filed simply had these changes, materially changing her interpretation from the fetal monitor script. Gave no reasons for the changes at all. It just listed changes, and that was submitted. We then filed a motion to suppress that errata sheet because it didn't comply with the rules. Thereafter, 2 months later, this nurse submits another errata sheet where she purports to list the reason for the change. And as Your Honor knows, under Rule 30.05, when you're going to make changes, you make the change and you say why. What is occasioning this change? And her statements were clarification of my answer. But she materially changed what she had testified to. That would be like saying the traffic light is red, I go home, I study it. You know what? The traffic light's green. So I make that change and then I put clarifying my answer. What she signed on June 14th, 2 months late, did not meet the requirements of the rule, even then. And it was only 4 days later, on June 18th, she then files an affidavit purporting to explain the reason. The problem with that is it's not a take-home test. And that's what we've created.
Mr. Halton?
Yes, ma'am.
How do you get around the plain language of the rule, which specifies that parties can change both the form and the substance of their testimony? I understand your argument that it, kind of guts the purpose of a deposition, but that's the language that's in the rule. So how do we get around that?
Well, if we're going to apply the rule strictly, we apply the whole rule. She had 30 days to make the changes and state the reason she didn't do it. It was 60 days that she did it. So if we're going to strictly apply the rule, I would submit we must also apply all of the rule, which requires it to have been done by April 16th in the proper format. And that did not occur. It was 2 months later. Last, if I can just quickly on the Dr. Sammer issue, Dr. Sammer was a treating physician who lives in Texas at the time of this trial. She submitted a declaration about when she believed the damage to the child occurred. The trial court found that she was not an expert specifically. However, the court ordered that she submit to a discovery deposition. Ultimately, the doctor hired counsel. She filed a motion to quash in Texas state courts. They didn't quash it. And then she refused to give 2 depositions. The error there, I would submit, is that the trial court imposed a burden on this witness as if she were an expert. That's the only place in Tennessee where we find discovery depositions for experts. The trial court decided, no, I'm going to make her give a discovery deposition, which is not allowed for under the rules. And I see my time's up. I'm sorry.
You have your time for rebuttal. We're here from the appellees. Have y'all divided your time?
We have, Your Honor. I'm Dixie Cooper here on behalf of Dr. Sieber and Ms. Mercer, and I'm going to use 9 minutes. I'm going to cover the Lewis versus Brooks issue and the Mercer errata sheet issue, and then Mr. Powers will respond to the Dr. Sammers issue.
That'll be fine. Thank you.
So first of all, there are 2 questions that are at issue from the trial court regarding me asserting Lewis versus Brooks on behalf of Dr. Sieber in this case. They are contained in Sieber's deposition, which is part of the record on page 216 and on page 224. Both questions unequivocally relate to care before Dr. Sieber was called to come and assist during this delivery. This lady was in the hospital for a number of days, and the care that's at issue in this case is the last couple of hours of the tracing when the mom is pushing, trying to get the baby delivered. The record is undisputed that Dr. Sieber was not involved in that patient's care at any time that day, and that nurse midwife Mercer is not only privileged to treat patients like this, but she's entitled to take the care of the patient from the beginning of the labor until delivery, unless a complication occurs.
Who does she work for?
She worked for Caring Choice, actually. So she was an employee of Caring Choice, which is the practice group that Dr. Sieber worked under.
Yeah.
Now,
who supervised her then? Was Dr. Sieber her supervisor?
Yes, sir. He was her supervisor, but his supervision.
And this was Dr. Sieber's patient?
Actually, it was the group's patient, and Ms. Borngne, the mom, actually chose Ms. Mercer to deliver her baby, not Dr. Sieber. They give the patients the option at the group, and she chose Ms. Mercer to do her delivery. So she was a patient of the group.
Who was the admitting physician?
Well, Dr. Siebers is listed as the admitting physician, Your Honor, but that's because of an Erlanger hospital rule. It has nothing to do with the supervisor relationship between Ms. Mercer and Dr. Sieber. It's an Erlanger requirement.
Does she have no supervisor?
No, she has a supervisor.
Well, who? Who's her supervisor?
She does have a supervisor, and it is Dr. Sieber. That is true.
All right. So the trial court said that they couldn't ask the plaintiff's lawyer couldn't ask Dr. Sieber whether or not this employee that he supervised should or shouldn't have called him.
No, that's not what he asked him. What he asked him was, would you, if Ms. Mercer, this is on page 216 of his deposition, if Ms. Mercer had been aware of the change in the variability of the heart rate and the late decelerations that were occurring with the pushing, what would you expect of your employee, the one you're supervising in this scenario? The other question asked.
That's not the same question I asked. Seems pretty similar to me.
I apologize, Your Honor.
Well, no, I must have asked it unclear. I mean, was the question, what would you, give me the last part of that question again, what would you expect her to do? Or
what would you expect her to do as your employee, which she was not his employee, and the one you're supervising? He's not actually supervising her at that point, Your Honor. And here's what's different.
So nobody's supervising her.
Well, he's not supervising her during this labor. The supervision.
So it's your position that nobody's supervising her.
Well, he is available to provide supervision when she needs it.
It's a yes or no answer.
He is her supervising physician. That is true.
All right.
There's no question that he is the supervising physician. But
under the Erlanger's point of view, he is the supervising physician, isn't he?
Of course. But
all right.
But
what was the other question?
The other question was, would it concern you that your patient had been in the hospital with minimal variability and lates for more than an hour before somebody bothered to call you? So the question is couched in terms of Mr. Holton's acknowledgement that Dr. Sieber had not been called to provide assistance to this patient. So in other words, the record shows, but not only with Dr. Sieber's testimony, but Ms. Mercer's testimony, which is unrefuted, is that she is permitted to have a patient admitted to the hospital, follow that patient from beginning to end if the patient can deliver vaginally. In this particular case, Ms. Borngne did not make progress moving the baby's head down so a vaginal delivery could occur. And there was some concern about the tracing. That is an issue where she then has the right and obligation to call her supervising physician, Dr. Sieber, and say, I need you to come to the bedside, which he did. And none of Dr. Sieber's involvement was off limits to Mr. Holton. I told him he could ask him any questions about Dr. Sieber's involvement, his conversation with Ms. Mercer, what he did when he got to the bedside, what he did, because he was a defendant in the case and his care was at issue. But the supervisory role, Your Honor, is governed by state regulations, and those regulations are set up to say that you have to have a supervising physician as a mid-level provider, but that supervision involves going to and providing assistance when that mid-level person requested, which Dr. Sieber did in this case, and reviewing 20% of the midwife's charts over in any range of time at a month at a time. So Dr. Sieber has to randomly review 20% of her charts. He doesn't have to be with her at this delivery. He doesn't have to monitor what she's doing. The regulations provide, and it's a little surprising that it's that limited, but the supervisory position is, you don't have, as a mid-level, you don't have to have a physician in the building with you, whether you're taking care of a patient in the office or in the hospital. But you do have, the supervisor does have to be available if the mid-level is having problems and needs assistance. And that's what he was doing.
I'm sorry, I know I'm asking you a lot.
It's okay.
The regulations require that the supervising physician be available if the midwife believes she needs him.
Yes, sir.
Isn't it? I don't understand why supervising physician wouldn't be in a position to answer whether or not he would have expected the midwife to do at a particular time, given the facts of that case.
Well, I think it has everything to do with the language in Lewis versus Brooks. What the Court of Appeals said is you can't ask a person about anything unless they're disclosed to provide other testimony. You can only ask an individual, a physician in this case, about questions related to their own actions. That's what the language in Lewis versus Brooks says, their own actions, which means when he gets invoked to act, which is at 2318 when Nurse Mercer calls him, then he's in the case and his actions are in play and he is subject to scrutiny in that regard.
What about
one other thing? Go ahead.
Sorry, go ahead.
One other thing I wanted to mention, Mr. Holton said the Lewis versus Brooks case is different because Dr. Lawrence and Dr. Moore, the two people he wanted to depose on these issues about Dr. Brooke, didn't have a relationship with Dr. Brooke. They absolutely did have a relationship with Dr. Brooke. Dr. Brooke was their agent. It was their patient. They provided all the prenatal care to this patient, but they retained Dr. Brooks to be the on-call physician, and she happened to come in when he was on call. So at a minimum, he is their actual agent relative to the care of this patient. So there is clearly a relationship there. And yet, despite that relationship, the court said, you can only ask Dr. Lawrence and Dr. Moore about their own actions. And that's where I think Lewis versus Brooks comes in to prevent Mr. Holton from asking Sieber questions about things he knew nothing about, had no involvement with before he was called.
Things he knew nothing about.
Yes, sir. He's not required to know that.
Whether or not he would have expected the midwife to contact him under a certain factual situation.
Well, she does have to let him know that the patient's in the hospital. That's undisputed.
But he can't answer whether or not this situation is one where she should have let him know.
Well, if she had asked him, if she had contacted him to ask him about the tracing and said, I understand what you're saying. You're saying he's free and clear. And apparently the group is too. You know, we keep, and I know your time's up, but I want to ask you something because Sure.
I find this really pretty fascinating. The group is also a defendant, correct?
Yes, sir.
She works for the group.
Yes, sir.
Was there, as does, I guess,
Dr. Sieber.
Dr. Sieber, thank you. They both work for the Duke. Is there anybody with the group, under your interpretation of Lewis, who would have been qualified to say whether this midwife should or should not have contacted the supervising physician? Or is that just off limits?
No, I don't think Dr. Sieber's incompetent. My position is simply that Lewis versus Brooks says, unless he declares himself an expert against someone, and if he does that, then absolutely it's game on.
I understand. My question, though, was applying Lewis the way you say it is there anybody with Caring Choice Women's Center PC that would have been competent or that would have been appropriate that the plaintiff's lawyer could have asked them should the midwife had contacted the supervising physician?
No, sir. Now, Caring Choice and Dr. Sieber can be liable for her actions. Absolutely.
Wait, I understand, but I'm going to keep you on this. So okay. You're saying that there is nobody with Caring Choice, the employer, who should be allowed to testify whether or not the midwife should have contacted the supervising physician.
Well, the only person who'd be competent in this scenario would be Siebers.
So your answer
the rest
is,
of the people are personnel without.
I understand, and I'm not talking about relevant, whether or not they're competent to give opinion, but I'm just saying, under your view, then there is nobody with her employer who should be allowed to testify or required to testify as to whether or not she should have contacted the supervising physician.
That is correct under Lewis versus Brooke, Your Honor.
Okay, thank you.
And I'm sorry I didn't get to talk about the errata sheet, but you'll have my brief.
Well, yes, and there are a lot of really interesting questions in this lawsuit. I will tell you that. Once upon a time, I probably all of you know it, at least some of you do know it. Yeah, I did a lot of medical malpractice, and it was all defense. I don't know if that's good or bad for anybody, but okay, yes. Mr. Powers, we'll hear from you.
Yes, sir, Judge. Thank you very much, and good afternoon. May it please the court. I'm Josh Powers with the Baker Donaldson firm, and I represented Erlanger in this matter. And I'm going to address the Dr. Sammer issue. And I think one set of facts that are very important, which the plaintiff really ignored in their brief with respect to Dr. Sammer, that absolutely affects the legal analysis, is the fact that this complaint was filed in 2015. That same year, defendants served interrogatories on plaintiff asking, if you're going to have a treating physician offer standard of care or causation testimony against the defendants, tell us who they are and what their opinions are. The plaintiff waited for over 3 years to supplement and answer that interrogatory. And when they did, it was 36 days before trial. And Judge Swinney, as I'm sure, based on your experience, the amount of effort it takes to prepare for a trial of this nature. So clearly that late supplementation was a prejudice to the defendants. And as a result, the defendants filed a motion to exclude. At the hearing, what's important is Judge Bennett denied the defendant's motion to exclude and ruled that Dr. Sammer could testify as to any opinions that she formed as part of her treatment of this patient. But the trial court went on to acknowledge clearly the defendants have been prejudiced by such a late supplementation. And Judge Bennett asked Ms. Cooper and I, do you want a continuance? Our response to the court was, yes, we would like a continuance, but we would also like the opportunity, but it conditioned on our opportunity to take the discovery deposition of Dr. Sammer. This is the key fact. The plaintiff did not object to our request. Hearing no objection, Judge Bennett granted the continuance based on our request that we get to take a discovery deposition of Dr. Sammer. That ends the analysis really right there, because we cited the Oldham versus Pickett case that says that, the well-established rule in Tennessee that a party must complain and seek relief immediately after any occurrence of a prejudicial event. Well, the plaintiff's silence was absolute acquiescence. We would not have agreed to a continuance of the trial had we not been able to get that discovery deposition. And then for plaintiff then to later come back after the fact, after remaining silent at the hearing, this was an in-person hearing. So the fact that under the Oldham case, we believe that has been waived. The plaintiff didn't object and they can't later come back and claim the contrary. I think that ends the analysis. But if you go beyond there, what you see is Judge Bennett and defense counsel literally bending over backwards to accommodate Dr. Sammer. We said we would take your deposition anywhere, anytime, whatever is good with you to accommodate your schedule. Her response was to file a motion to quash. We then filed another motion to exclude, which was then also denied. And Judge Bennett, really kind of ahead of the curve, said, okay, this is a year before COVID, said, all right, if the court in Texas grants the motion to quash, I want to have a McDaniel hearing, and we can do it by Zoom, we can do it in person, either one. This is a year before COVID. But if the court denies the motion to quash, then the deposition will proceed. The court in Texas denied the motion to quash, and the response that we got was a letter from Dr. Sammer's lawyer saying that this time commitment, it's too much time commitment. I can't do this. Well, that makes it, first of all, it was a voluntary decision on her part not to testify, period. That's the end of the story. But she's willing to travel from Houston, Texas to Chattanooga, Tennessee to testify live, but she's not willing for Ms. Cooper and I to travel to Houston, Texas at the time and place of her choosing and get paid for us to take a deposition for 2 or 3 hours. That doesn't make any sense. Judge Bennett bent over backwards, and his decision was under the protective. We outlined it on page 25 of our brief. We quoted it. I thought his ruling was very articulate and well put together, that this was under Rule 26. The other issue that I was going to address real briefly is the pre-majority medical expenses. Obviously it was a defense verdict. The jury never even got to damages. So I think that's a non-issue. But I think the only point I would leave with the court is that the plaintiff is conflating the right to subrogation with a liability of this child to pay the medical bills. Those are two different things, because it's clear under Tennessee law that when a minor child is injured, it creates two causes of action, one cause of action for the parent and another cause of action for the child. And it was the mother's claim for the medical bills, not the child's claim. And the only other thing I would just point out real quickly is in Lewis v. Brooks, I think Judge Davis, I think you hit the nail on the head. The nature of the relationship is not the determinative factor. It's whether you can compel the product of another's brain. And Dr. Brooks, in this case, it's in the case. It says, in the opinion, it says there was a claim by the plaintiff that Moore and Lawrence were negligent in selecting Dr. Brooks to be the on-duty physician. So there was a claim directly against him. I've gone over my time. Thank you very much for your time this afternoon.
Thank you. We're here from hear from the appellant rebuttal.
Just briefly on the Sammer issue, the Dr. Sammer, we got a hold of her right before trial. She was not real happy to be involved. I spoke with her. She gave a declaration where she said, in my opinion, as the treating neurologist, this injury occurred at or about time of delivery. As soon as we got that, we have amended our interrogatories. We advised defendants of this. More importantly, though, the defendants sought and got a QPO over our objection from the trial court to talk to all physicians, including Dr. Sammer. They never bothered to talk to her for 3 years of litigation. The issue with Dr. Sammer, and I'll just cover it briefly, she was subjected to a discovery deposition. If we in Tennessee expect physicians in other states to assist in our search for the truth in our trials in Tennessee, I don't think it's fair to place a burden on them to give 2 depositions, particularly when they have already been recognized by the court as not being experts. This lady had to hire a lawyer, pay a lawyer to oppose this through the Texas courts because she did not want to be deposed twice, which we recognize in our state. No one has to do that except a paid expert.
Mr. Horton, I think, I'm sorry to interrupt you. I think the defendant's response to that would be, if she were truly just a factual witness, that would not have happened or been necessary. But the fact that she then, shortly before trial, apparently gave an opinion on causation, it's my understanding from the defendants that was the new information that they received that did, I mean, she was giving an opinion on causation, and that's what necessitated the discovery deposition.
But she was giving that as a treating physician, not as an expert. I didn't retain her. I didn't pay her. These were facts she knew from her own work. This is not where she looks at someone else's record and makes a decision about when something happened. That's the Sammer issue. Again, on Dr. Sieber, she was his employee or the group's employee, but his quote that it means I am ultimately responsible for the care of the patient. I don't know how much clearer he could say it. He was responsible for whatever Mercer did. He was her supervisor. It was his patient under his name at that facility, and he admitted freely it was his responsibility. The 2 questions we have are just the 2 we adjourned on. As Judge Sweeney, I'm sure you know, having defended malpractice cases, there's a lot of roads I would have gone down about the strip and what about this and should you have been called? I wouldn't have stopped there. But the trial court stopped me and sanctioned me for asking the supervisor, the party responsible, about the conduct of his supervisee and his employee.
Thank you. Thanks to all three counsel. It's your briefs and oral argument were all very, very helpful. It's very well done, both the briefs and the oral arguments. Mr. Hibner, will you please recess court till our next case this afternoon?
This honorable court is now in recess until 2:30 p.m.
Thank you.
Thank you.